All friends, as you know, we are wading through very difficult times. The entire world, or say the entire human existence, is presently fighting against an unseen enemy, the pandemic COVID 19, or the coronavirus as we call it, with no definite vaccine for its prevention and no definite medicine for its cure for the present. The only preventive measures in our hands being social distancing, personal hygiene, and sanitization. This has necessitated our meeting or the seminar to be held through webinars. Necessity being the mother of invention, the seminars are now being held through webinars. Friends, today our topic for discussion is the speedy disposal of cases in the family courts, tools and techniques, roles of the principal judges of the family courts. This topic makes us to ponder as to what was the necessity to bring the family courts in existence at all. Where the works which we are carrying out through family courts jurisdiction were not being carried out in the regular courts earlier. If that was being effectively carried out, what was the need for creating the new jurisdiction? Friends, in our earlier times, our lives were not very complicated. We used to live simple lives. The family used to be close linked relationship and closely knitted relationship between comparatively large number of people in joint families. There was virtually no scope or very limited scope of tussle between the members of families. And even if they were there, they used to be solved by the elder members of the family itself. Very seldom the dispute used to come to the level of the courts. They used to be resolved at the family level or best at the society level itself. We have our ancient scriptures of all the religions laying down the laws relating to marriage, maintenance, adoption, guardianship, etc., which were being followed by the mankind. In Hindu religion, the marriage was considered to be a sacrosanct union of two individuals of opposite sex, which was separable only by death. There was no concept of divorce in Hindu law. In Islam, it was considered only as a contract which could be broken by talaq. Likewise, there used to be different laws for different religions or groups of society, which were being very meticulously followed without there being much scope for conflict of interest. Even if there be conflict of interest, in most of the cases, they used to be itself. Over the passage of time, there was a tremendous change in our lifestyle. As we became more and more aware and conscious of our rights, the joint families disintegrated, and gradually it became at times difficult even to maintain that knit of relationship even in the small families. The sacrosanct nature of relationship almost evaporated by the consciousness of our rights, giving rise to more and more complicated issues. Matrimonial relations in many cases became traumatic experience in the lives of the partners and their children. Apart from the emotional problems, it gave rise to many social and legal complications. And a time came when the legislature realized that these complicated disputes now no more can be handled on the basis of our ancient scriptures alone, and the necessity was felt for codifying the laws. The laws were accordingly codified, but were being enforced by the regular courts of law according to the jurisdiction vested by the particular act. But there was lack of sensitivity by which the family disputes were required to be handled. By the passage of time, the legislature realized that these complicated disputes now must be handled by specially trained and sensitized judges in the field and not by the regular courts of law. In fact, the movement to establish family courts in India was actually initiated even before passing before the Hindu Marriage Act 1955. It was initiated by late Durgabai Deshmukh, a noted social worker from Maharashtra. She had occasion to visit China in the year 1953, and she had the occasion to study the working of the family courts there. On her return back to India, she discussed the subject with the eminent judges and the legal experts of her time and submitted a proposal to set up the family courts in India as well to the then Prime Minister of India, late Jawaharlal Nehru. Subsequently, the Law Commission of India, in its 44th report on the Code of Civil Procedure, strongly recommended the need of especially handling the matters pertaining to divorce. 59th report of the Law Commission also made similar recommendations. Consequently, the Code of Civil Procedure was amended and Order 32A was incorporated in it in the year 1976, setting out the procedure to be followed in the suits relating to the matters concerning the family. Rule 3 of Order 32A of CPC casted a duty upon the courts to make endeavor to assist the parties in arriving at a settlement. However, the courts did not make much use of this provision and continued to deal with the adversary approach. Much blame perhaps cannot be put on the courts of those times, as the courts were already over-docketed with the civil disputes and the criminal cases and could not be expected to have the sensitivity required in dealing with the family disputes, as they were already overburdened with other civil and criminal disputes, which were consuming most of the time of the courts, and the time taken in settling the disputes by the courts used to take years together, in some cases more than 20 to 30 years. This was such a, it was such a scenario in which the Family Courts Act 1984 was enacted by the Parliament. The main objectives and reasons for setting up the family courts are: one, to create a specialized court which will exclusively deal with the family matters so that a court may have the necessary expertise to deal with these cases expeditiously. Thus, expertise and expedition are the two main factors for establishing these courts. Second, to initiate a mechanism for conciliation of the disputes relating to family. Third, to provide an inexpensive remedy. And fourth, to have the flexibility and informal atmosphere in the conduct of the proceedings. Even the necessity of parties being represented by the advocates have been done away with in the Family Courts Act, and it has been left open to the court to seek the assistance of a legal expert as an amicus curiae if it thinks that to be necessary in the interest of justice. Much emphasis has been laid for amicable settlement of dispute and settlement of dispute expeditiously. Friends, with these objectives behind, it is always necessary for us, while presiding over the family courts, to sensitize ourselves to deal with the family disputes. Not only to sensitize ourselves, but also to make ourselves more and more aware to the new developments of law. We cannot act with the same indifferent attitude towards unnecessary adjournments and rigidity towards the procedural aspects with which we used to act a few years ago. There is flexibility all around, but at the same time, due precaution is to be exercised, particularly while dealing with the child matters such as custody, adoption, and guardianship. Friends, when the parents are hostile to each other, a child or children are under psychological stress, which situation is very difficult to resolve. This is a dangerous situation which may have a lifetime adverse impact on the personality of the child. At times, we have experienced even the mothers having hostile attitudes even against the well-being of her child due to the hostile attitude with her husband. The same may be the situation other way around also, but the child becomes the victim of this hostile situation. Not only that, the child needs the love and affection of both the parents, but even the parents, in spite of all hostility amongst themselves, do not want to part with his or her love and affection towards the child. It is very aptly held in Yashita Sahu's case that if we cannot provide one happy home with two parents to the child, then let the child have the benefit of two happy homes with one parent each. One of such situation, both myself and brother Aparesh Kumar Singh have faced in the High Court recently, when we found the mother to be extremely hostile towards the well-being of her own child, and she resisted with all force in her command, even the better education of her child. At times, we had to pass very harsh orders, keeping in view the welfare of the child, and our orders were challenged at all stages in the apex court by the mother, but the orders were upheld by the apex court. The reference of that case is there in the booklet circulated to you. I hope the Director Judicial Officer, Judicial Academy must have circulated the booklet to you.
My lord, we will circulate the booklet after the program.
Or you will be circulating it after the program.
Yes, my lord. After the
Anyway, you will be getting the reference in that booklet. Needless to say that in such situations, the matters related to the custody of child or the shared parenthood or the visitation rights of the parents to the child have to be decided with utmost sensitivity and precaution. The other aspect is the time factor, which we cannot allow to be unnecessarily wasted. Such a situation is always detrimental to both the parties, even though one of them may unknowingly be interested in delaying the matter. The service of notice to the respondent is a very important aspect. which should always be very carefully taken care of by the judges manning the family courts. The cunning litigants have the tendency to avoid giving correct address of the adversary so that the notice may not be served or inappropriately shown to be served so that the party may get the matter decided in his or her favor ex parte. I have had the occasion to see the ex parte decree where the summons and the notices were sent, and even publication of the substituted notice was made at such place where the party was not reasonably expected to be present. This was a case in which the respondent was in place, but no notice was ever sent or published at the place where she was working. The courts need to be careful about this aspect as well. The process of online service of notice through email or SMS should also be resorted to, taking all precautions of its service to the right person. At the first instance, after having the first interface with the parties, there must all there must be all endeavor on part of the court to get the dispute amicably settled. The adversarial approach of settling the dispute must come only after all the efforts of amicable settlement are failed. But there should be a reasonable time frame to be followed in the matters of conciliation, and they too cannot be allowed to be unduly prolonged. In fact, there should be a perfect time management by the courts for all the stages to be taken in the matter, and all endeavors should be made to decide the dispute within the fixed time frame. The questions which have been circulated to you by the Judicial Academy were the most pertinent questions to be answered by. I have gone through your answers, but the lucid manner in which these questions have been answered by the Judicial Academy, which has just been found by the Director Judicial Academy, shall be circulated to you shortly. Shall certainly go a long way in making you more sensitized and a more seasoned family judge. And friends, the present situation of the pandemic is likely to continue. Even after the situation normalizes, we shall perhaps not be in a position to have the normal functioning of the courts. A lot of advocates, litigants, and family tasks gathering with the court services. Such gatherings cannot be allowed for a long time to come, as we have previously in old point. Wherever there is a relaxation in number of cases and as we consider this. Accordingly, the virtual suits are going to reality and we have trapped ourselves to the new suits.
Meeting the
Is there any difficulty? Is there any difficulty?
Yes, this audio is not so audible, brother.
Is there any difficulty?
The audio is not very clear in the last 1 or 2 minutes.
Okay, I'm repeating it. Friends, the present situation of pandemic is likely to be longer than the pandemic.
इधर जब we shall be perhaps not be in a position to have the normal functioning of the courts with lots of advocates, litigants, and arbiters gathering. Such gatherings cannot be allowed alone as we have experienced worldwide. Wherever there is a relaxation in the long run, the number of cases of epidemic have considerably increased. Accordingly, the virtual courts are going to be reality, and we have to adapt ourselves to the new techniques of holding the courts by video conference. The sooner we adapt, the better. Are now to be held online, and we have already started this process, and a few matters have also been successful. Now, you can also make online reference of the matters. This process is going to continue for long, and it has its own benefits. Earlier, the conciliation or mediation had to be adjourned if one party absented itself. Now, this situation can be minimized and confined only to the genuine difficulties of the parties. Now, the conciliation and mediation can be held online while the respective parties are still at their homes. No more excuses that the parties are not present. From Jhalsa, we have taken steps to provide platforms to the mediators and the parties for online mediation in case any of them having any difficulty. Dear friends, with these few words, I advise you to take this unfortunate situation as a boon in disguise and to start the work of dispensation of justice with more zeal and taking all help of new technology. We have to prepare ourselves to effectively respond to the call of society and to prepare even for the paperless digital courts. The E-Committee is working hard on this project, and we are perhaps going to have a solution very soon in the near future. We have to work even if the pandemic situation continues longer than our expectation. After all, we cannot shut our responsibilities for a long time, and we have to adapt ourselves to the new situation. We have to keep in mind that the survival is always of the fittest only. With these few words, dear friends, I now request Brother Justice Apresh Kumar Singh to enlighten you with his presentation. Thank you and stay safe.
Thank you, my lords. May I request my lord, Honorable Mr. Justice Apresh sir, to make the presentation and moderate further session. Screen.
Family court across the state. This experience is both all of you and us that we are having an online refresher session or a webinar on how to equip, train, and deal with our responsibilities in the age of this coronavirus. I'm grateful to the Honorable Chief Justice and Chairman, Judge in charge of the Judicial Academy to have given impetus to this kind of a concept. Judicial Academy can't sit idle in these times when physical presence of the judicial officers or other components of our justice delivery system are unable to physically come to the academy to engage in these workshops or training sessions. And this challenge has thrown an opportunity for all of us. Therefore, this had to be done sooner or later, and as some of us be aware, other judicial academies have also been taking a lead in it, because the show must go on and we cannot stop and sit idle. Now, one thing is for sure, that this virtual functioning of courts or these online training sessions, webinars, these things are going to stay. About a week back, while we were also deliberating on this issue, or rather 10 days back when we were also deliberating on this issue, the official statement of the Honorable Apex Court also came, as we saw on the websites, that even after the pandemic, these virtual courts would function along with the traditional courts. Now we need to gear up to face India being a huge country, and though our e-courts project has progressed to a great extent under the leadership of the Supreme Court Committee, but because it is dependent upon not only the stakeholders in the judiciary, but for all technical know-how, financial support, etc., hardware, meeting with the new challenges, there are different stakeholders. The digitization, or for that matter, complete achievement of the goals of the policy paper of the E-Committee has not yet been achieved, not yet been done. But this pandemic has actually given a great, in fact, impetus to make it more and more. And dear presiding officers, will realize that the functioning of these virtual court system, which everyone has to get used to, depends upon not only the judges or the registry members, but also the litigants and the lawyers. At least these are the four stakeholders of this working for the proper, efficient functioning of this system. And the challenges are huge. Incidentally, I had got the benefit of going through a paper published by Vidhi, Center for Legal Policy, Virtual Courts in India, a strategy paper. This is of April 2020. And this has been prepared during the Corona times. and it has been prepared with the guidance of Honorable Justice Lokur, Justice Badar Durej Ahmad, in fact, former Attorney General Mr. Mukul Rohatgi, and other eminent jurists and personalities in the field. Now, to understand it in a simpler way, this paper, which I would just briefly touch upon, says that this online dispute redressal mechanism, or as it is called ODR, this actually are in different stages. And what we think of virtual courts, or often talk about virtual courts, is the ultimate stage of this online dispute redressal mechanism. Virtual court, in effect, means that right from the stage of filing of the application by a litigant or a lawyer till the case is finally decided, there is no manual interface in between. Everything is done electronically. Now that is not yet possible because of the progress or the time being taken in adoption by all of us. But it is also true that this virtual court, in the truest sense, would be limited to matters such as those in which evidence through virtual courts or other interface of litigants, witnesses, etc., in a traditional trial court is not needed. So what this paper suggests, that there are at least 3 stages. We loosely call it virtual court, but what we are doing now is running the court through video conferencing. Our filing of cases in a proper e-filing format has not yet been done because we are in the process of finalizing the e-filing rules, both for the High Court and the district courts. And therefore, what we are doing now during the epidemic and even thereafter, which we might have to do, is to take up cases through video conferencing, which cases actually do not require physical presence of the parties or the lawyers. Now, cutting short this conceptual part of the virtual court system, I would only point out that in this ODR system, there are different stages. Not all cases can be transferred to a virtual court, given the nature of the cases, but a step lesser than that or 2 steps lesser than that could be, for example, that certain processes can be done online, like the notice part, like the filing part. But when you have to actually conduct a trial, maybe at the present stage of our readiness, we are not so equipped to actually hold the trial of cases, not specifically talking about the family court, but other subordinate courts as well. Therefore, in the last directive that the High Court has issued to you, you must have come across that evidence taking has been advised to be avoided. In fact, in no case evidence should be taken, because that would require the presence of the witnesses and lawyers and crowding of the court and the kind of restrictions operating during the lockdown may not be possible for the judiciary alone to enforce it when movement, etc., is not permissible, intra-district or inter-districts, etc. So, the last directive that the High Court has issued, probably on 4th of May, is to increase the class and nature of cases which subordinate courts could take up through video conference. And in that, apart from other nature and class of cases, specifically concerning the family courts, the mutual divorce through mutual consent, that kind of case, maintenance case, and if I may say so, reading it, cases which are at the stage of final arguments where the presence of the litigant or the lawyer is not necessary. These guidelines further gives you this freedom to engage in online mediation also. So when this webinar was conceptualized, it started off with the family court because family courts are actually doing a yeoman service in the sense Brother Mishra has already explained it to you, for the objects and reasons for which the family courts and other matrimonial or other kind of matrimonial family court matters, law relating to family court matters have been legislated. And therefore, we took upon this task as a trial run for that matter with the family court judges in the first instance. Now, I understand that after the directive of 4th of May, probably all the family courts in our state must have started taking up these matters through video conferencing by following the protocol. I'll get to know during some brief interaction with some of you after I complete my address. What I have found that from the inputs provided from you, from each of the family courts, that there are several cases pending in which application under section 13B has been filed, and there are number of cases pending at the final stage of argument in all your courts. In fact, in Jamshedpur, there are 157 plus 41, that is 198 cases under 13B and pending in both the courts, principal judge and additional judge. And in the other, this final argument cases also, there are quite 25 and 38. Similarly, depending upon the size of the family court and district, there are many cases in other family courts also. So therefore, these are the matters which can effectively be taken at this stage through video conferencing and engage you also, and at the same time enable you to do some judicial work and give relief to the litigant parties. Now, for example, in the 13B kind of cases, suppose the cases have been filed in the last 5, 6 or 3, 4 months, and the first motion had already happened. Or there might be cases where 13B cases are ready to be filed by the parties because they have already consented to mutual divorce. Now, if you entertain these applications or sort out the pending 13B applications in which dates were fixed in these months, then if you take an initiative to inform the parties to appear through video conferencing and their lawyers, then these 13B applications can be easily decided. And for that, the Family Court Acts gives you sufficient leverage. And apart from that, the judgment of the apex court also gives you sufficient direction that video conferencing in such matters can be held if both the parties are consenting. Now you also have the option on the request of the parties to waive off the cooling period depending upon fulfillment of the laid down criteria as per the Supreme Court judgment. So these matters can be taken up, and I believe they are being taken up. I got an input from Jamshedpur Judgeship, which is under my administrative jurisdiction, that these matters have been taken up in the last 4 or 5 days, and few final stage argument cases have also been taken up. Judgments are being pronounced. And there is one example of day before yesterday, I think, also where the mediation has been successful. The wife was residing at Bangalore, and the matrimonial dispute has been successfully resolved through online mediation. So these kind of cases can be easily taken up through video conferencing. You have also been given maintenance cases also, because that is also a necessity for those who are actually much dependent upon financial assistance from the estranged partner. So I may also reiterate that this online mediation thing has been given a go-ahead by Jhalsa, and at Ranchi also this online mediation has been held. It has been successful also. So we can't lag behind. We can't lag behind compared to other high courts or other district courts, and we have to keep pace with the times, these difficult times. I also understand that any judicial officer, or for that matter, any judge who has this ingrained habit of actually working 24/7, and that too almost 365 days in the year, despite all the holidays and vacations, the kind of schedule that every judicial officer in our state or in the country as a whole, considering the limited number of judicial judges in the entire country in proportion to the total population. So all the judges have been trained and are engaged in a very routine or scheduled manner to function. And sitting idle for 40 days or 45 days is a great challenge to our mental faculties also. So therefore, this webinar of today is actually, in a way, a trial run for you to start functioning, to facilitate your functioning in a manner through video conferencing, so long the e-court filing rules are not yet notified, and also to get over the initial jitters or initial hiccups in the functioning of the system. As you know, earlier only one license was given by NIC, that is the video app, to every district court, and the High Court was given 5 video licenses. Now that video license and video conferencing through that video app was being done in the High Court also. And it was not a very satisfying experience for different reasons, because it might be an old app and bandwidth may not be there, or during the normal working hours, it was being used by other agencies of the Government of India or other public sector organizations, because that is maintained by the NIC. So realizing this, directives came from the Supreme Court E-Committee also, and our High Court has also issued directives to you to adopt other such web applications through which you can actually hold court through video conferencing. And I believe in all districts, use of apps like Jitsi or WebEx or some other app, Google Meet, etc. These are being tried. Our experience shows that we are in the stage of a trial, and the best one ultimately we will likely adopt. Will adopt in most likely coming days. We are going through that trial run. So, in running the courts through video conferencing for these limited nature of cases, the actual functioning has few challenges. And though before I interact with you on certain issues, I would just share with you the standard operating procedures actually, which we have to follow here, or I had the opportunity to go through a webinar of Delhi High Court judges. They have also beautifully given an SOP kind of thing for ensuring seamless functioning of these courts through video conference. Now what happens is that in the functioning of the video court, court through video conferencing, VC court, you have to first identify the case. Then you have to either take initiative from your end if the date of the case is fixed during the pandemic, or if there is a request for taking up the case from the litigant or the lawyer, to have the consent of both the sides. And then when that kind of case is identified, then you have to fix a date and a time slot in which that particular case is to be taken up. Now, once you fix that date and time, suppose you are preparing a list of cases which you are going to take up through video conferencing. Say there are 5 cases for today. Now, in that way, you have to give the intimation of that particular case to the concerned lawyers and litigants of both the sides, that the meeting or the court is scheduled at 10:30 or 11 or 7:30 or 8, this morning court going on. And this would last for half an hour. The next case is scheduled for, say, 11 after half an hour, depending upon the volume of the litigation or the time which it might likely consume. Then your court master, yourself, your secretaries, stenographers, they also have to be fully sensitized and in fact trained as to how to allow the joining of these litigants, lawyers in the virtual court or the court to VC. And they should only be allowed to join. Not that if you have 5 cases, you allow all those litigants and lawyers to join you at the same time and create a chaos in the virtual court or the court through VC. So this requires repeated either communicating through telephone or through email. And our experience, and perhaps your experience, would also show that often the functioning gets interrupted because some or the other stakeholder or even the judge or the PO gets disconnected, or his voice or video gets interrupted. So these are the initial hiccups in the functioning of the system, and it is quite frustrating. So the court master, if he is controlling all these appearances through his remote desk, then he has to ensure that he immediately gets it reconnected by calling the concerned litigant lawyer that you have got disconnected or some audio is not there, or sometimes with the judge also, or sometimes with the court master himself if he is not sitting in the court. So during the functioning of these court through video conferencing, lot of hiccups come. The effort should be to ensure that it is not affected because of these interruptions. So this is one part which I wanted to say, this SOP part, which I have also learned through experience and through the webinar which I just saw of the Delhi High Court judges addressing on this issue. Now, after this particular case is heard and say you have reserved it, then you have to ensure that the judgments are timely prepared and delivered on any particular day, or if you are in a position to deliver the judgment then and there, then the parties will have to be in the listening, and after its correction, it has to be uploaded on the website without any delay so that the parties can get the web copy of the judgment and go back home satisfied, or if they are not satisfied, they can lay a challenge. So these are the issues which actually the video conferencing courts are facing across the country, even in the high courts, even in places like Delhi. And it is a huge task for the court master or the person who is actually remote controlling the functioning of the court. You can yourself do that also. You can train your court master and the secretary to indulge in all this, because sometimes it may not be possible for you to do all these things while holding the court also. So in this way, you can stagger the identified cases in your cause list as per the consent of the parties and take it up on the court working days, one after the other, one after the other, and one after the other. So these are the methods by which you can ensure that you function effectively through these video conferencing courts and are able to deliver justice. So now, having given a piece of my mind on these issues and having got the benefit of listening to my elder brother Justice Mishra on the wider canvas of the role and functioning of the family courts, I would briefly have a few interactive questions with some of the family court judges as to what they are doing at their level and if they are facing difficulties in this regard. So, for example, I would like to ask Mr. Nikesh, who is Principal Family Devghar.
Lordship.
Are you hearing, Mr. Nikesh?
Lordship.
Now, please tell us that after the directives of this, our High Court to all of you, have you been able to identify the cases under 30B and the final arguments cases or maintenance cases?
Yes,
and,
Lordship.
We got request for its urgent hearing through litigation, or have you scheduled the dates of such cases to be taken up through by following these protocols which I just shared with all of you?
Lordship. We have identified, in fact, 42 cases of 13B, which are posted in different dates, and out of which 11 cases are ready cases, my lord, in which parties can approach for second motion. But so far, none of the parties have rather approached the court or made any request to us. But we are trying from our end to contact the parties and motivate them to get their cases disposed of through the video conferencing facility or webinar facility.
Now, suppose in your jurisdiction, Devghar being not a very cosmopolitan city
Lordship,
compared to Jamshedpur or Ranchi, suppose you take an initiative to ask the concerned parties to ensure their appearance with consent in such a 13B matter,
Lordship.
expecting a response considering the from which they are coming, say in rural areas or they are not so equipped with this gadgets
Exactly,
and phones or
exactly.
network facilities. Is it feasible?
Exactly, Lordship. In many cases, the parties don't have even mobile numbers. They don't have any smartphones or as such to get connected with us. And we are requesting the lawyers to give the consent memorandum on behalf of the parties wherever the parties are available on a smartphone, or we can get them connected through video conferencing from remote areas.
Okay. So till now you have not any 13B pending cases or no new 13B cases have been filed.
No new case of 13B has been filed, my lord, and I hope that in the next week we can take up some 13B cases, my lord.
Okay. And you have certain cases for final arguments also. In that,
Yes,
what
Lord.
is the progress?
I've disposed of one maintenance case, my lord, and the problem is the initial teething problem is there that the other party is not available. So in three cases we have I have done part hearing, and those cases are posted for Monday. I expect that the lawyers will be available.
Now,
We'll see.
do you require the presence of the party also, or for final arguments, the lawyers can do their bit?
Uh, we expect that the lawyers have the consent of their parties, my lord. That they have implied consent through their wakalatnama. If they are ready, then lordship,
That is true.
lordship.
So, what do the lawyers in Devghar district have this, are well equipped in terms of these gadgets and network to address your family
Not at all.
from a remote?
Not at all, lordship. There are very few lawyers. In fact, out of the number of posted cases, we are only able to take up one or two cases on each day, my lord. So
No,
far.
you are able to take up through video, or they have to come?
No, through video conferencing. Through video Jitsi app, I am using, my lord, Jitsi app.
Oh, very well. Till now, you had the experience of conferencing through any app, and did you encounter these kind of hiccups during the holding of the court?
The Jitsi app is very compatible, I think, due to connectivity, good connectivity in this area, lordship.
But you cannot schedule the meeting from before in that.
Exactly. I normally I do it through my bench clerk, who informs the parties that the court is ready. I can get connected. We are sending the link.
So prior intimation is only of a message, not the link.
Through message and through telephone call, lord.
No, these other apps have this facility of sending the link that your meeting is scheduled or court is scheduled at 10:30. Please join at 10.
Yes,
That is
has
not
to send-
possible in Jitsi.
Actually, that we can do it. We do it through our bench clerk, who informs the parties about that password and that password to join the meeting. That meeting number is there.
Can I have, or can we have the, thank you, Nikesh. Can we have the experience of, say, Mr. Satyaprakash, number 2, Principal Judge, Family Court, Dhanbad.
Thank you, Lordship.
Mrs. Sanjita also from Dhanbad, Additional Principal Judge.
Satprakash, please come online. Switch on your video and audio.
Yes, sir.
Yes. My lord has
Yes, Mr. Satprakash and Mrs. Sanjita.
Ram, sir.
Lordship.
You heard
Ram, Lordship.
address and the question that I put to Mr. Nikesh. Can you please share your own experiences so far in these matters?
Yes, sir. As far as disposal of these cases by through video conferencing is concerned.
In your court, Mr. Satprakash, there are 88 matters pending for 13B and 15 for final argument. And before Mrs. Sanjita, there are 8 pending for 13B and 58 for final argument.
Yeah, yes, sir.
So have you been able
Yes,
to
sir.
make any?
I'm
Yes, please go ahead.
yes, sir. I'm hearing argument through Jitsi app and Cisco WebEx, sir. And one judgment has already been passed in one case, sir.
Okay. So you have the Dhanbad lawyers. Are they equipped and are they in addressing through video court? Video
So not more
conferencing?
equipped. Sometimes they are not connected, sir.
No. How are you scheduling the cases? Are you contacting the lawyers or they are making a request, then you are taking up?
Lawyers send messages mailed on my mobile phone. Thereafter, I connected them.
So you are you not taking initiative? Say there are final arguments in which dates have crossed or dates are due to come, and you know that only the final arguments are to be made through video conferencing. They need not physically come. So why not take initiative in that and have a fixed cost list of such 4 or 5 ready cases on as per your convenience and their consent?
Okay, sir. I will take initiative.
I think with the approval of my elder brother Justice Mishra on the lines on which I am addressing you, family court should take up this initiative, sir. What do you?
Surely.
Otherwise, the whole purpose would not fructify.
Surely.
Please take up some initiative so that you are also engaged and some cases will be disposed of, and these times you have plenty of time actually. You are free, everyone
Yes, sir.
are
Sir.
free. So if you
Yes,
hear
sir.
this, you reserve argument, you can deliver a proper judgment and upload it. Otherwise,
Sir, I will
it's not going to
take.
serve purpose. This pendency is going to mount because we are not able to dispose of cases during this time. So as many cases and needy cases, this final argument or 13B cases are cases which are ripe or which may become ripe, 13B cases.
Sir, I will take, sir. Thank you.
Mr. Satprakash, you have heard us because you went. The Principal Judge Dhanbad, has he been hearing us? Seems he is not. Anyway, one more interaction with Mr. Sri Prakash Dubey, Sahibganj.
Because please switch on.
Ram Lodge.
Now Sanjita and Satprakash may switch off their video and go in mute mode, and Sri Prakash will switch on his video and audio.
Mr. Sri Prakash, are you?
Sri Prakash, at present, he is disconnected, sir. It appears there is some connectivity issue.
Very well. Then I can ask, because Jamshedpur is a very busy family court judgeship. We ask from Mr. Sunil Kumar Singh, number 2, and Mr. Neeraj Srivastav. Are you online, both of you?
My lord. Yes.
Please
Yes.
keep your video and audio both on.
Yes, I'm already on.
So, yes, Mr. Neeraj on your side, yes. Tell us your experience on these issues which we just deliberated. Any difficulty?
Actually, my lord, we come at court in court hours time,
Okay.
and we select all the cases, and we phone all the advocates concerned, because there is no in general, we don't receive any positive response from their side.
No,
But
just a minute. Do you not engage in a preliminary exercise 1 day or 2 days before?
Actually, they are ready. Actually, they are ready on the date when the case is fixed.
No, but you or your registry can take an initiative to tell them to be equipped and prepared, say day after tomorrow their case are going to be taken up at a particular time. So can you not inform them today, 2 days before, and take their consent?
We do this also, my lord.
Pardon?
We do these things also, my lord. Prior to Mr. Neeru.
A bit of push required, because people have to feel comfortable. They have to adopt this system.
My lord.
In the district courts, it is rather challenging, because both in terms of this gazette and the network bandwidth, etc., it is more challenging. So you people have to, and Jamshedpur judgeship, and especially Jamshedpur has a better facility compared to other places. The lawyers or litigants also, they have more cosmopolitan and well-educated class of litigants actually. So you have to be a bit proactive in these things, where the litigants and the lawyers are in better situation compared to the more districts, for example, Simdega or Gumla, Pakur. These are places, Jamshedpur, Ranchi, Dhanbad, Bokaro, especially. These are places where if you do a bit of pushing, every lawyer has a smartphone nowadays, and they can actually understand that it is useful and beneficial to do the court through video conferencing, of course, subject to being an seamless, effective kind of a functioning. Mr. Sunil Singh, are you able to do an?
Yes, I'm hearing lordship. Pranam, my lord. Am I audible, my lord?
Yes.
Just after, sir, just after receiving order of the honorable court, I started taking initiative, informing the concerned lawyer, send them link. They joined with us, and thereafter we do heard counsel for the parties. Until now, I have already decided 5 cases, 3 cases of maintenance, 2 cases of and in coming week, we are all taking the matter very seriously, and hopefully, I will dispose of more than 50 cases within this month.
That's a very optimistic commitment from your side, and I hope that you succeed in that, you have to.
Lordship, 25 cases are pending in my court for argument, my lord. And
Okay.
I have every day we are taking 3, 4 cases, 5 cases every day. Actually, I'm not very friendly with the system, but gradually we are improving.
Nobody is actually friendly, but everybody has to train himself, and that is a huge challenge. That's a challenge to the system, to the organization, and on all these fronts, we from the High Court are trying to actually facilitate the filing rules or the infrastructure like bandwidth or licensed app, and thirdly, training. You have to train your own staff also so that they are able to handle. Now, while you are holding, you are also indulging in getting these lawyers or litigants connected, then it distracts your attention. So your court master, bench clerk should be actually equipped and trained to handle all that.
Lordship, they are assisting me. They are assisting me.
So a little bit of effort in the initial days will put this system in a streamline, and I hope and wish that all of you take positive lessons out of this webinar, and every place, although I'm not able to interact, we are not able to interact with all of you, but whatever is the message, please take it with you in a positive manner during the lockdown and even after the lockdown, when we have to further broaden the nature of cases and the stages in which we can take it up through video conferencing. This also, please keep it in mind. Maybe at all stages, video conferencing would not be successful even in a family court, but you'll have to identify the stage of a particular case where you can simply, with the consent of the parties, hold a video conferencing court instead of asking them to crowd in the court and wait till their case is taken up. Because social distancing, minimum of crowding, etc., has to be the norm for the next 6 months or 1 year at least, till everybody has the immunity and every vaccine has come in place, etc. So on this note, I would like to close my address and then request Mr. Chaudhary
Thank you, my lord.
carry on.
Thank you, my lord. We have two distinguished panelists who have joined. Miss Malvika Rajkotia, she will be speaking on, will be giving her presentation on family matters, family court matters. Malvika Rajkotia had also come earlier in our Judicial Academy, and she had made good presentations, and we received very good feedbacks regarding her. So she joins from Delhi, and another panelist that is there is N.S. Lipinagi. She is also advocate Supreme Court, but she will be joining from Bombay. She will be giving us some idea about nitty-gritty of virtual court. So I request my lord to moderate the further sessions, my lord.
Mr.
Lord,
Chaudhary, I missed your last few words.
I request your lordship to moderate this further session with your permissions. My lord, there is some connectivity issue. My lord.
Mr. Chaudhary,
Yes, my lord.
are you going to moderate this session, or we are supposed to be joining?
I request my lord, if your lordship can spare some time to be with us in this session for some time.
Okay. Subject to what Brother Mishra has to say, I just wanted to take leave for 10 minutes for some reason.
Thank you, my lord.
Okay, brother, you may leave. I shall
Okay,
also for some time and then I will.
Yes,
I'll join again.
Yes, my lord.
Yes, yes.
Madam, with the permission of the chair, Madam, to start.
Yes, yes.
Uh, do I begin?
Surely.
Okay. So, thank you very much for inviting me in these very unusual and unprecedented, and therefore almost it is historic. And we are actually gearing towards something which would have been so ordinary and run of the mill as to what are the tools and techniques for speedy disposal. If the same question had been asked of me 6 months ago, because of course disposal is always an issue, this particular angle and this which has created an extra urgency would certainly not have been there. So perhaps we could use this pandemic crisis to reinvent ourselves, to be on a trajectory which is efficient and fast, because more than ever before, speed without the sacrifice of justice, of course, is important. And with these additional technological aids that this pandemic has constrained us to adopt, surely the speed is something that we can use to our advantage now. So I was given a set of 8 questions by the Academy, and my office and we worked on our responses, and we emailed that to the Academy, and I'm hoping that that is perhaps as some outline case material which the judges would find useful in their day-to-day work in terms of information, some case law and so on, which I'm sure they're already familiar with, but it's just curating what we thought was important for the questions. Then, of course, comes the so we'll take each question separately. To begin with, the first question was tools and techniques for speedy disposal of matrimonial and other matters pending in family courts. So, judging by his response on trying to educate bench clerks, lawyers, litigants to come into the stream of technology for efficiency purposes, and that's obviously an ongoing exercise. But my information that I have given you must be with a caveat, because this I've noticed even the last time the 2 times when I've been privileged to come to Ranchi, has been that obviously the Delhi situation, the cosmopolitan situation, the case law that is developed or comes from the Supreme Court in those contexts is not perhaps opposite for the class, economic and social classes that are in the various and wide districts of Jharkhand. But be that as it may, the answer to the first question would be, as is already being done from 10:15 onwards, with regard to how to address the matter of backlogs. Now, our research has shown that at present there are more than 22 million cases pending in various courts across the country. And matrimonial relief, unfortunately, it's only now with academies like yourself and family courts are giving family law an importance which when I began my career in 1985, it certainly didn't have. So I think the first thing which would help in streamlining is the fact that there is a family court. It was passed in 1985 in Delhi. It came through only eventually. They were set up in as recently as 2007. And even then it was a question as to what is the jurisdiction. But today, the most important thing I think is the geographical and therefore all the jurisprudence that emanates from one block is more important because it's not diffused. And that is an important consideration for the development of these, of speed. Practically, my experience in Delhi has been that bench clerks very often, left with giving dates, do not prioritize to necessarily to the extent that is required. So to that extent, the intervention of the the judicial officer to control next dates of hearing, practically speaking, to my mind, is very important. So therefore, we shouldn't have to end up pleading to say, please give us a date earlier because it's this, that, and the other. It is a response that needs to come from the judicial officer. And the judicial officer, more than anybody else, knows the constraint of his or her own diary. And that is an interaction that could happen at that. Then we come to the question of witnesses. I do believe that since the Family Courts Act requires not a detailed evidence and cross-examination, the Act itself allows for an exemption. The Act itself simply says that a statement is to be recorded. A statement of the witness is to be recorded. So procedurally, unfortunately, what we are lapsing into is that family court proceedings are treated on par with a commercial court, for example, or a civil court, most important, where cross-examination is on very minute detail of pleadings. Whereas the purpose of the Family Courts Act was to remove that as non-essential. Because it's not a property matter. It's about noting demeanor. Now, in the minutiae of detail, sometimes the demeanor gets lost. So one way of perhaps, am I audible? Am I audible?
Yes, you are audible.
So one way would perhaps be for a judge to cut through the detailed evidence affidavits which are required and simply have, it is supposed to be section 15, record of oral evidence. So section 15 of the Family Courts Act says the judge can simply record the statement of why you have that case. Why do you want a divorce? And why do you want to resist the divorce? What are the issues in the marriage if I give the divorce? The issue as to finance, as to children. What are the issues if I deny the divorce? What are you left with? That's basically the corners and the parameters of a family litigation. So the detailed pleadings as to when an incident happened with regard to cruelty, etc., which used to be from 1976 onwards, when divorce was not a right. That certainly can get diluted now if we could, or get streamlined now, if we could record oral evidence and straight away go to the cross-examination. Now, oral evidence recording, according to me, considering that it will be with the witness directly, is a possibility to do on video conferencing. Maybe a cross-examination need not be, because sometimes a cross-examination, the physical presence of the witness is important. But be that as it may, certainly the first statement recorded by the judge can be done by video conferencing facilities, and that's a lot of saving of time. Now, the other is a very practical thing. For example, when notices are issued to parties, sometimes court fee is not paid for months together and dates just get lost. So I think there should be a specific date given, process fee to be filed within the day, summons to issue the following day. So that kind of non-starter, which happens because of sheer negligence or lassitude or whatever it is, at least that can get streamlined. Sorry, what? Yeah, or the court fee can be taken in advance. That's another good reason. The other is sometimes witnesses are turned away unexamined for lack of time. Video conferencing could be useful for that as well, because witness would have come a long way, there is payments, etc. New technology can be used for long distance cross-examination as well, which I do believe is an important innovation, which we can use technology to our advantage. Of course, the rest I've seen how the family court judges have been responding to the queries by the high court judges on what is expected. And it has been quite a privilege actually to watch that interaction. And, there's very little I can say, except that as a lawyer, these are the constraints that I find when I go into a family court or when I go to the high court with regard to family matters. Number one, they are not given the priority of many other type of matters. So therefore, my constant complaint as a family lawyer to every judge is, please do believe that family law matters. It is an important area of litigation, and a lot of the backlog and workload of case pendency is in the area of family law. Probably after the Government of India litigation, the next litigation is probably family law. And it is something that is relatively benign and yet deals with very important and deep individual issues, which can be addressed with some degree of empathy. We could actually work towards producing great jurisprudential strides in this area. Now, the rest are the obvious ones. Obviously, long dates, should there be, those are which each high court will take charge of on its own, but this was my response. Now we come to the second question, which is in what manner and to what extent the procedure in family courts can be evolved for speedy disposal of cases. So that I've already drawn the attention of the learned judges to section 15 to say most of the time gets lost in long protracted legal evidence. And since every judge has the power to develop his or her own procedure, it is very important for the judge to balance the rights of the parties to come up with a procedure that is inclusive of all rights concerned without being intrusive. And yet the balancing act is simply when I'm balancing equities. If I give a divorce, what is the consequence on the one who has responding and resisting the divorce? If I don't give the divorce, what is the consequence to the person who's denied the divorce? The grounds of divorce, are they made out in pleadings? I only want an oral overstatement. While making that oral statement, the golden opportunity, which is lost most of the time, is the issue of watching demeanor. And my suggestion in watching demeanor is bona fide litigant, bona fide resistance. Are there bona fide claims? Are children being tutored? Stronger co-parenting arrangements where there are attempts to withhold a child, then the court can come out more strongly on the question of co-parenting, keeping in mind, obviously, the nuances of each case with regard to gender, financial rights, and such like. In Delhi, we are using a lot of counseling and therapists and child therapists also. Now, I would imagine that perhaps that kind of very expert and nuanced professionalism of this very, very niche area of therapy may not be available on the ground in all districts in Jharkhand. But this is again when technology can be used for video conferencing with therapists, for judges to take advice on issues by having a bank of various therapists and experts who could advise a judge on the human aspect, apart from the legal aspect of the matrimonial issue. So technology again can be used for that purpose. The third question is an academic question. And it is in a matrimonial suit for divorce filed by the husband on the ground of cruelty and desertion, the wife appears and admits desertion, but makes counter allegation on cruelty. We've given a very long, detailed answer along with the citations of courts of Bombay and the issue of admissions and the law with regard to admissions. The sum and substance of this question is as follows. And admission cannot be used against a party unless it is unconditional. Therefore, when a wife says that, yes, I admit I deserted, it cannot be unconditional if she is also pleading cruelty. Because then it becomes a question that I deserted is her understanding that I left the house because of his cruelty. And therefore, the desertion does not constitute a matrimonial offense, number one, which would entitle the husband to a divorce, because the desertion is not on her account, but it has been created. She was compelled to flee by the husband because of his cruel conduct, and she has already pleaded that cruel conduct. So it becomes a hybrid case. Her plea of admission of desertion is immaterial, because the circumstances of that desertion are such that it does not constitute desertion as a matrimonial fault. And therefore, her admission is of no value under Order 12, Rule 6. It is not unconditional. And therefore, the focus has to go back to the issue of her plea for cruelty, which has to be now. If she fails in establishing that he was cruel, then yes, it could be that the desertion was without cause. So it becomes, you cannot really, they are not two separate silos. It's all mingling into each other. Husband saying she deserted me, she saying yes, I left because he was cruel. But if she says yes, I left, it cannot constitute a unconditional admission under Order 12, Rule 6 as desertion. Sorry, my learned friend is pointing out something. Yes. Also, I would call everybody's attention to, again, Section 23A, which is that a husband, no party can take advantage of their own wrong. So if you feel that you have, if my client, the husband, has filed for divorce, but if the wife's complaint is that in fact, it is he who is cruel, then the relief to my client will be barred by the principle of Section 23A, which says no party can take advantage of his or her own wrong while asking for a relief. And while the court gives the relief, the court will have to balance whether in fact they are rewarding a misconduct. So the legal principle would be for the judge to say, am I rewarding misconduct of marital misconduct? And I would like to take it to the next level to say that judges today need to also see whether they are rewarding litigation misconduct. I would like to use and suggest that to you as a phrase that can be used, that justice does not mean that the judge rewards litigation misconduct, which is why the whole issue of bona fide litigation and demeanor, particularly in matrimonial litigation, becomes the most important. Coming to the next question, fourth question is, due to strained relations between the parents, a child who ideally needs the company of both parents feels tormented. The task is then on the court to decide as to whom the custody should be given. What are the various objective considerations to be kept in mind in awarding shared parenting orders? Discuss in the light of latest case laws. So again, I have given my answer, which I have emailed to the Academy, which would be material that is available to all the judges with all the case law, the latest case law as well. The one in 2020 was passed in the Supreme Court, Yashita Sahu. In fact, that was a matter that our office had represented the mother in. And it is an important, even before any of this, the pandemic, Justice Gupta has used technology in suggesting access, that even when there is geographical distance between the parents and the children, or the distant parent and the non-custodial parent and the child, then certainly there can be FaceTime, there can be, such like conference calls and so on, video conferencing, by which a parent can continue to maintain a relationship with the child to the extent possible. Technology permitting here is not the only impediment, may I say. What is also going to be an impediment, which I often find, is very often the custodial parent tends to discourage contact with the non-custodial parent. Sometimes it is for good reason, because the non-custodial parent may be abusive or otherwise malintended in pursuing the litigation. But sometimes it is nothing but a program to alienate the child from the parent as a vindictive measure, or simply perhaps to hold a child hostage till all matters are settled. The nuances are many. However, here again, the catchphrase, the key phrase, which I would like to suggest is demeanor. The Delhi High Court, My Lord Justice Najmi Waziri, in a case of Shilpa Mannan, we've sent that? Okay, we'll send that. It was a case where custody was reversed. The mother had been granted custody by the father had been granted custody by some visitation by the lower court. Mother kept interfering with that visitation, making it impossible, and the High Court reversed the custody and said, because of this lack of clear, transparent lack of bona fides, it is in the interest of the child to be away from this mother, because the plan to distance a child from the other parent was viewed as another form of child abuse. So that is a detail which we can, we've emailed, and the relevant paragraph is para 26 and 30. The case is Shilpi Thapar versus, sorry?
Madam, just this citation will suffice. You give the citation.
We'll just...
citation will
yeah. Okay. I've got the Manu Patra citation. So it's a 2015 case, High Court, Justice Waziri, Shilpi Thapar versus Manan Thapar. Sum and substance being, in all the three questions which I've answered so far, the first one, video conference can be used to use demeanor. The second one, demeanor tends to get ignored in prolonged minutiae evidence where the steno is recording it and the judge is not able to. So this is an opportunity for that kind of evidence and that kind of affidavits to those long evidence affidavits to go out. The judge will simply record oral evidence, and while recording it, make a separate note on what the judge believes to be the demeanor of the litigant. And this is something that could become useful even for the higher courts, because higher courts are not able to note demeanor. So today, if I had to continue to pick up two key phrases which come to my mind in this presentation, the first will be shortness of procedure, no need for long affidavit by way of evidence, every opportunity taken to note demeanor. While balancing equities, please bear in mind that judicial justice just does not serve litigation misconduct. And that is again apparent from the demeanor. Coming to the fourth question, fortunately, since the material is all with you, one can go quicker. We've just dealt with the shared parenting orders. Now coming to the fifth question. What are the practical difficulties in execution of an order for grant of maintenance? Discuss the available options in law before a family judge for the realization of maintenance, with specific reference to case laws. Now, this has been done. You have the material before you. Now, the issue is really the decree holder needs to know the details of the properties of the judgment debtor. Now, most of the time, for lack of disclosure, it becomes a bit of a stabbing in the dark, because there are very few wives who would actually know the details of hidden assets. So in Delhi, we have developed the procedure where every matrimonial case of all parties, petitioner as well as respondent, have to file income tax returns and details of their property, and the purpose, and a separate financial affidavit. And the case is Kusum Sharma, the details of the citation, which we can email to you. That judgment and the format of that affidavit allows for you to do a forensic analysis of the financial status of the concerned parties. And that forensic analysis, as we know, cannot just be based upon income tax returns, because unfortunately, we also know, and our Supreme Court has noted, that income tax returns very rarely are a true indicator of a person's wealth, particularly of somebody who is an entrepreneur or a business person, and so on. So in that context, the address, how many holidays you took, where all did you travel, what class do you travel? Obviously, I'm talking of a cosmopolitan context. But the same can be modified to a specific sociological context for the place where the family court is, to do that for forensic analysis. And it could be simple questions that the judge could ask to make that assessment for himself or herself, and perhaps make a note of that. Once we have those details, then attachment of those properties can become easier. Now, the law technically is that basically execution applications have to be filed for 1 year. And each year we end up 125 is wide enough by itself for there to be no need to file a separate execution petition. And the judge, as a family court judge, at the seniority that he or she has, certainly has the power to insist upon bypassing that procedure, to make a simple application to say you will not be heard any further, your defense is closed till such time as payment is made. Because we cannot again get lost in the morass of procedure with regard to how to realize money. So therefore, that is again something that the Family Courts Act 125 mandate itself as a social welfare legislation allows you boldly to, you can more than anybody else see what's happening in your court, and you can see that when somebody says he does not have the money, you will know whether he's telling the truth or not. And you do have the power to be able to do that forensic analysis for yourselves with certain specific questions and details, and pass an order accordingly, rather than waiting for yet another petition, for yet another execution, for yet another, because those are precisely the kind of little petty minutiae details that the legislature again and again is empowering you to do. You can bypass it. 125 allows you to do it. As a family court judge, the Family Courts Act allows you to develop your own procedure, and 125 cases are now before a family court judge. They are not before a magistrate. So that is a huge advantage that the court has. The relevant case law and our suggestions we have already sent by email. The sixth question, and I've come to my last but one. There's one more after this. What are the principles for computation of maintenance under Section 125? How will the quantum of maintenance vary in case the competent court has awarded maintenance under the Domestic Violence Act and under Section 24? So this is an academic question, really speaking, because practically what I have noticed is that because 24 and 125 cases are invariably in the same court. They are in the family court. After the Family Courts Act, 125 cases have gone to the family court. So a family judge may well have two petitions before him or her. They would be either the divorce, within which the Section 24 would have been filed, or separate maintenance petition under section 125. Now, either the two can be merged together for the purposes only for the purposes of maintenance. Now, the Domestic Violence Act is a speedy remedy primarily used for continuance of shelter and perhaps maintenance or status quo with regard to the utilities, etc., of that shelter. But that act in itself also has a specific provision in the rules framed with that act, that if you have received any benefits from any other welfare legislation for the purposes of maintenance, you are bound to disclose it. Now, here the family judge will know, because 24 is also within the same court, unless, of course, it's in a different district because of jurisdiction purposes. But it's not something that one needs to spend too much time on expending anxiety about, because you won't need to do it. The other side is bound to say she's already getting so much from such and such place. So the question is, the law is also that you can't be limited to exercising only one remedy. And the reason is obvious. The women would be to one remedy, but of delays. So sometimes one court is important in any court for that woman who is going through amount. So she will knock on every door that is available. Now, for the purpose of cohesion, yes, the judge will find out, and obviously that factor will be taken into consideration, that such and such court has already awarded this much. However, we will relook at it and perhaps say that it should be more. It can't be less. So that is the separate. 125 may not be able to give less, certainly may not be able to even increase. But section 24 gives you the power to increase the amount which a woman may have got under 125 or under domestic violence, because both those acts are for speedy need to avoid destitution, of course in the context of lifestyle, but all the same. Section 24 is a wider civil proceeding which can have more nuance and detail and forensic analysis, and therefore a 24 amount can be higher. And a judge may say, well, you have got so much under section 125, but I do believe that you should get more. And I do believe that that is within the power of a judge to do. Now, coming to the seventh question, the difference between the Hindu Minority and Guardianship Act and the Guardians and Wards Act. It's an interesting question because the fact of the matter is that the Guardians and Wards Act is an 1890 Act, and the other act is a 1956 Act. The truth of the matter is that the Guardians and Wards Act after that has not developed much by statute and amendment as much as it has developed by judicial interpretation. So the Guardians and Wards Act originally is an overwhelmingly patriarchal and father-centric act, as the guardian with the power, with the control, and so on and so forth. The Hindu Minority and Guardianship Act is a more gender-friendly act, and therefore more modern in its view on gender, obviously considering that it's passed more than 100 years later. But the truth of the matter is that both today are being read on par. So the differences in a tabular form have already been shared with the judges in the email that we have sent. And the primary difference is that the Guardians and Wards Act, being paternal-centric, the importance of the mother in that act has only come with judicial rulings. Whereas by statute, the Hindu Minority and Guardianship Act has asserted the maternal preference rule at least up till the child is 6 years old. So that is however, the fact that the maternal preference is till the child is 6 years old is keeping in mind the welfare of the child. And therefore, that is a principle that could well be absorbed while ruling under the Guardians and Wards Act, because the central issue with regard to both, of course, is the welfare of the child. So what are the concomitants of the welfare of the child? The statute of the Hindu Minority and Guardianship Act has already given you an indicator to say the maternal preference rule. There is no reason why that could not get by osmosis absorbed into the Guardians and Wards Act as an important rule for the benefit of the child. So all of this diffused jurisprudence that is emerging on the issue of welfare child, whether it's under habeas corpus, whether it's under custody battles of Section 26 under the Hindu Marriage Act or the Special Marriage Act, or whether under the Hindu Minority and Guardianship Act or under the Guardians and Wards Act. It seems diffused, but the core, once you consider that it is what prevails is the welfare, one can pick up all of these various contexts from all these other statutes to develop a jurisprudence on what is indeed and are indicators of the child's welfare. An important act today, which is also being read on the concept of welfare, is the Juvenile Justice Act, which traditionally was not being brought into the matrimonial courts at all, but now is, because it's the issue of the child's identity. So, for example, we are doing a case where the father has abducted the child, converted to Islam, said that because I am now living in a Middle Eastern country and my child is mine and Islamic, and therefore that child must also be Islamic, we managed to get an order from the from the Delhi High Court for return of the child. But an important aspect of welfare, when we talk about it, is the right to the child's identity, which is the identity that she was unilaterally has foisted upon her, which is an identity, which is a cultural identity, which could be a sociological, social context identity, and so on. Coming to the last question, it is very, we've given you a fair amount of material. My office had, we've done a lot. It's a very interesting question. I had not expected it from, but I imagine that perhaps the adoption is a great issue. Perhaps that's the reason why family court judges are having to deal with adoption law. So the question is, what are the major difference in procedure for adoption by Indian prospective adoptive parents living in India and inter-country adoption? What are the eligibility criteria for prospective adoptive parents discussed with relevant provision of law and latest case laws? So, I mean, the only reason, perhaps what I thought why this question came was that there must be adoption agencies which are working in...
Interesting.
Sorry. Sorry, should I continue?
Yes.
So I would imagine that perhaps it is because adoption centers there are NGOs perhaps working with adoptions, and family courts are constrained to rule on adoption or verify adoption because the child is the ward of the court. So obviously, while looking to the safety of the child, the court has to make an assessment as to the parents to whom who are going to be taking the child in adoption. Where what the NGO does, it has to be verified. So the detail of that is already with you in detail, but I will take this moment to share a case that I did about 15 years ago, no, I think about 20 years ago actually, on adoption, where a mother, my client was the adoptive mother. She had picked up a child from the, adopted a child from the SOS village. But when it was time, after the fostering being completed, foster period was 2 years. After completing that, when she moved the papers for finalization of the adoption papers, the biological mother emerged and said, I want the child back. And the lower court, in a order which was quite stunning in its lack of empathy, simply asked that because that child is the biological of the biological mother, the child must be handed over immediately to the biological mother. while the assessment is done as to whether the adoption is bona fide or not. Now, we obviously challenged that the next day in the High Court and got a stay so the child could continue to be with the mother till the end of the case. But what was important is that we did a due diligence research on the woman who claimed to be the biological mother. And what emerged was that she could well have been the biological mother, that is true. But it was a daughter that she left at the railway station. Now, very clearly, she abandoned at the railway station and never, ever made a complaint of a missing child. But obviously was then watching as to where the child would go and found the home. And when the papers were moved in the family court for finalization of the adoption process, she wanted to negotiate a sum of money to abandon her claim, which of course we did not allow. We did not succeed. We did not let them succeed. And it was before Justice Vikramjit Sen in the High Court, who later went to the Supreme Court, and he simply asked that one question. Sorry, I'm sorry, I'm trying to. So we simply said that in those scenarios, what we want is that the judge asked, why would you leave the child in the railway station? And if you did, then very clearly you have done it for a monetary value now and were watching the child. So SOS, which is why I say judges have to be careful even with regard to the NGO. So the NGO concerned played a role which was questionable because it was not transparent in its dealings with us. And we do believe that material and our filings were communicated to the biological mother to create an impediment for financial gain. So the judge obviously has to be extremely, extremely alert about these kind of things, and most important about the purpose, the welfare, and why is that child being adopted? I mean, you don't want to send a child abroad to be able to be, for the cooking and cleaning to be done in that house. So those are the bona fides that need to be checked, the details of which we have put in our answers that we have circulated amongst the Academy members. And that was the last question. And I thank you very much for the opportunity, and thank you all for hearing me out.
Thank you, madam. But will you take some questions?
Yes, happy to.
So I request the participants to send their question, if any, so
Yes.
that the resource person can respond on that. But before the question comes, the participants.
Questions in the both वो उनको फॉरवर्ड किया था वही शमी ने, वो तुम उसको निकाल सकते हो.
But before the question comes, I had one question from you, madam. You had mentioned about recording of evidence of witnesses through video conferencing.
Yes.
So particularly when the witness is out station, the witness is from other station. So what is the protocol of identification of the witness, number one? And how do you get the signature of the witnesses? These are the issues. So what is the procedure that is being adopted there in Delhi?
Right. We can share with you the rules and of protocol that have been issued by the High Court here. But I had the opportunity of being a witness, expert witness on video conference for an American court. And the process of identification was that, I gave my name and so on and so forth. And the lawyer who introduced me verified my identity. That was one. I had to send I had to send a affidavit, which was stamped by a notary of Delhi, to also say that this is my standing as a lawyer and so on and so forth, which was before the judge when he was questioning me. So, and this in fact was something that was done 6 years ago. So expert witnesses, rather than flying somebody abroad and this and that because they wanted some nuance on family law and Hindu law, then I was available on Skype for this purpose, and I even took an oath based on how I wanted to take it as a secular person.
There is a question from Rakesh Kumar Singh, Principal Judge, Family Court, Kodda. What is the question?
Sir has written that there is no such law for computation of matrimonial matters compensation as compared to MV Act cases, or is there any such law?
Okay, so there is a judgment which I'll share with you in an insurance case. Justice Prabha Atre of, I think she was in Madhya Pradesh at that time, I can't remember, but I will forward you, but she has computed a woman's value in a insurance matter. Now, because we have to pick up from all the others and put it together so that it's not diffused and lost. So it's a good opportunity to gather these indicators. My view, personal view on the issue of maintenance and alimony, for example, is alimony, if you notice, I don't know whether that's true of Jharkhand, it probably is. There are very few judgments on alimony, but a lot on interim maintenance. And everybody pushes for interim maintenance as if it's going to be the final, because they think it's going to be so long, so we might as well treat it as final. And then everybody is too tired to fight for the alimony. So one way perhaps would be alimony straight away, including, to my mind, tenure of marriage is an important indicator on maintenance. So it's a simple principle of common law country developed in the UK, for example. What you put into the marriage is what you will get out of it. Of course, we can't import it without modification into our country, because in our country, the marriage also has a social value, which is of a different context, which is not there in the Western world. So tenure of marriage, for example, for a woman, once she's married, the divorce stigma she wants to avoid, even if it's after 1 year or if it's after 12 years. So the question is, what should the financial compensation be? But with a little bit of tweaking, I do believe that it's a good thumb rule that tenure of marriage, whether there are children, what is the economic parity between the parties? What is her, not just that she has the capacity to earn, but whether she has earned and has savings. That is with regard to maintenance from him. But somewhere you will then have to dovetail that maintenance claim, which is why the Protection of Women from Domestic Violence Act is there, and develop the law of tort, which is encompassed in that statute on the issue of damages. What is the damages of cruelty? What is the damages of further cruelty invariably compounded in a long, long litigation battle, invariably with the more empowered party is sometimes the man, sometimes it's the woman who's just unreasonably refusing the divorce. Now that too is litigation conduct that has to be taken into consideration while balancing financial award. So I won't call it maintenance. One aspect is maintenance. The other is financial parity. What is the property that they built together in the time of marriage? We don't have a concept of community property, but it's perhaps an important indicator, and we can use that to flavor our financial orders by developing the damage aspect and not putting everything into what we think is just maintenance. Because the moment you do that, the husbands have a right of appeal. But the moment you put it under separate heads and make it reasonable, it's a short tenure marriage, therefore this much. There are these children, therefore this much. This is what she earns. She needs it to be supplemented, therefore this much. But he has also been guilty of such other matrimonial crimes, has troubled her invariably. I regret to say that domestic violence we've seen during the lockdown, it's the women who are suffering. The balm, the heart balm that the judge can give will be in a damage award rather than in a maintenance award. Anything else?
Thank you, madam. I request my lord to further moderate the session. NS Napinai is with us, my lord, for the presentation on virtual courts reality. Thank you, madam, so much.
Thank you, my lords, and thank you all the judges. Thank you very much indeed.
May I request my lord to give the concluding remark of this session before Napinai madam joins for the next session.
Brief while I was had taken a break and I was not able to listen to the very profound thoughts that Ms. Kotia has shared, but Rajkotia has shared. But of course, at the later end, I gathered that it was a very incisive and very in-depth address and dealing with each and every question in a very analytical manner, and I'm sure that our family court judges must have benefited of it, and especially on the issues or the questions were also very interesting. Of course, I have also experienced sitting in the appellate jurisdiction in the family court matter, that this issue of alimony actually escapes notice for most of the time.
Yes.
And family court judges, including ourselves, actually grow up in the dark, both for two reasons. That enough materials have not come on record during the family court proceedings as to assess on all these parameters, as Mr. Rajkotia said, as to how much could the alimony be assessed and awarded to the lady. And at the same time, the sensitization on these issues in the family court also lacking. So many a times, what we do is to take a thumb rule that say the husband has been earning so much, the wife is a housewife, the marriage is of so many years. So just our guess estimation, we award say 10 lakhs, 15 lakhs, 20 lakhs staggered over a period of time, something kept for the children, etc. But otherwise, we find it very difficult, and on many occasions we have to ask the parties to go to the family court once again and to take this question of alimony in a separate proceeding. Yes. So that we understand that it is very onerous for the wife again to go back to raise a question of alimony. But if we do not have at the appellate court enough materials, we feel constrained as to award the alimony of any extent. Maybe it may become harsh towards the husband, or it may not be enough for the wife. So instead of doing something which may attain finality because of lack of challenge thereafter, we think that if the wife is really in need, she has the forum. And nowadays, the approach that I have adopted in my court is to ask the wives also in our proceedings, or even instruct the family courts also to extend them legal aid, because they come under the definition of person under section 12 of the Legal Services Authorities. So, Mr. Rajkotia, this is one thing which I wanted to share with you, and to the benefit of my all family court judges, is that in many cases in our appellate stage, we find that despite all steps for notice, the lady has not yet appeared. Obviously, she is the respondent. Then we have taken initiatives to ask my High Court Legal Services Authority. Incidentally, I am the chairman of the High Court Legal Services Committee, to ask the committee secretary to approach the lady on her address and mobile number, and then tell her that if you are in need of legal aid, we'll provide you legal aid. And we have very good counsels on the legal aid panel, both male, female, women. They are very keen and very hardworking. So many a times, I'll tell you an example. A lady was not appearing in the family court. She was not appearing in the appellate court, and this case was at the final stage. Now, the husband belongs to Ranchi, the well-off person, and the wife belongs to Karol Bagh or some other place. The matter is still pending. When I realized that despite all these efforts, she has not appeared, she may not be interested in actually contesting the matter. But still, we thought that there are so many allegations of cruelty, etc., against her. So we need to hear the other side of the story. Then, when we asked the secretary of the committee, he incidentally had the mobile numbers because in one of our FIRs, her mobile number was also there. And some maintenance amount had been given earlier on our account. So we tallied both the addresses and the mobile number. And when she was contacted, she had some good lawyer of Delhi. I'm told that from Haryana, some assistant advocate general or someone. He, in fact, on her behalf, called my secretary, went through many of my judgments to find out what kind of a judge I am. And then that though she is capable to have a private lawyer, but the seriousness and the empathy of the court shows that I'm really concerned about. So then they have engaged my legal aid counsel, and that case would, of course, be taken up after it reopens. So this is another aspect of the sensitization matter.
Yes.
So there are many ways. Sitting in the family court jurisdiction for the last 3 years in a staggered way, I have felt that every judge, for that matter, should sit in the family court jurisprudence. And this is perhaps a great humanizing and a great learning experience. Every day, you will not believe, at least 4 or 5 parties are physically present at the appellate stage before me, division bench, and invariably at the admission stage, the first step that I take is to send them for mediation. If they are from some far off place, we ensure that they first come immediately. In the second half, we send them for mediation to the Jharkhand State Legal Services Authority. And many times, with little bit of cajoling and the efforts of our mediators, the mediation proves to be very successful. And it is such a satisfying experience, we can't say more about it.
Yes.
Mr. Rajkotia, you have a wealth of experience on it, and we are really grateful to you to have shared all that with us. Thank you so much.
Thank you, and lovely to have met you, virtually met you all.
Thank you, and hope to see you at Ranchi, and we'll meet again.
Yeah, thank you. Thank you.
Thank you so much. Now we move on to our next very distinguished speaker, Ms. Napinai. She has come to Ranchi earlier also and addressed us. And there could not have been a better stage and opportunity during this lockdown period to hear from her on other aspects of the family law and before our family court judges. Over to Ms. Napinai.
Thank you, sir. I hope I'm audible. In case I'm not, please let me know. The time slot given was about an hour. What I will do is I will cut down on the presentation aspect and give more time for questions and answers, because the presentation and all the citations, everything in it, I've already shared with the Judicial Academy, and I'm sure the participants will get the benefit of the presentations from that. So I'm just going to move on to a screen share. I'm using the Codex screen share for the first time. So here goes. I hope the presentation is visible for all to see. So if I'm running out of time, I request somebody just give me a heads up because my screen is now fully blocked with my screen share. Uh, the qualifier before I start for today, I am not a family court practitioner, so pardon me if I miss any of the nuances uh, that go with practicing in this particular field. My specialization is in cyber laws, and of course, I predate cyber, so my original field of specialization was and continues to be substantially in criminal law also. So, with that qualifier, I move forward, and my presentation today is trying to focus not just on general cyber or general virtual court issues, but trying as much as possible to customize it to the family court aspects. These are the propositions which I wish to share going forward in today's session. And primarily, a lot of these issues have already been touched upon by the earlier speakers. So I will try my best not to repeat those aspects and move on to some of the more difficult issues or concerns that are going to meet courts willing to take up trial work, and particularly during COVID times. So one question that I saw when I was researching for this session was to equate the functioning of courts with, let's say, e-commerce. So there were a lot of issues that were brought up even when customers were to move from physical shopping to e-commerce. So the primary things were about, oh, you will lose your touch and feel, you will not have the same empathy, or you won't feel the same way when you're shopping online because there is a little bit of the distancing, and therefore it's always going to be shopping physically. I don't think anybody who was advocating or supporting physical shopping would have even dreamt of the kind of evolutionary process that e-shopping or e-commerce has brought to us. But when we ask this question, is it the same when we talk about courts? I would have to strongly but surely beg to differ. My take would be that we have our learnings from this exponential growth from physical shopping to e-commerce. But to equate both would be completely fallacious. But taking forward not just this aspect of learning, but also in terms of looking back before COVID, is this a concept of virtual court just something that has come up because of expediency? Is it something only because COVID forced us to sit at home and then talk to the world? Not really. This concept of virtual court predates COVID substantially. I've just given two examples. One goes back as far as 2002, and in both instances, the disputes that are being dealt with are commercial disputes. In Michigan, when they were deciding on virtual courts, all the issues we are going to talk about today in terms of what are the issues and concerns that a court will have to face if it is going to adapt virtual courts, not just during COVID, but beyond this also. A lot of answers may come from these two examples which I've given. And the very first thing I would want to point out here is please see the dates. The Michigan Court initiative started in 2002. It took nearly 10 years, and fast forwarding to 2012, for Michigan to come forward with an actual act to bring about cyber courts for commercial disputes. So when we look at the time and money that went into setting up cyber courts, it does seem daunting. Uh, the other example, which I'm going to be relying on heavily today in terms of what we can do during COVID and going forward, is the China example. And there is a lot that can happen because of this example. And I would say, thanks to, in a way, COVID, the silver lining to this otherwise dark phase. China introduced its e-commerce court in 2017. There are a lot of pluses and some minuses in this. I will be dealing with it as we come to this aspect of the actual functioning of these kind of courts as we are envisaging it. But that it can work and that it is already a reality way before COVID gives strength to the argument that virtual courts indeed is a reality. What are the issues and concerns? A lot of these issues and concerns have been highlighted before. But what I would like to walk you all through is to not just point out the issues and concerns, but also the case laws which may possibly support the argument for virtual courts. The first, and this is a reality today, and I have never seen the Supreme Court this empty, and it saddens me to use this picture, but this can be a very happy reality also tomorrow, because when we are in the Supreme Court, not only do we see diversity of people from across India, we also hear about the difficulties that people face when they have to come to the center from very far corners of India. So if we can take the courts to their doorstep, instead of them having to spend and to reach out to courts, what better way of really serving the litigants or the individual than this, right? So how and in what manner can we do that? The first construct I thought I should take up is the court as a public place, that which should be accessible to all. The very construct of justice being done and being seen to be done derives from this accessibility. But see where it can lead to also. These are just some of the provisions I've already shared. I'm just going to these in the presentation I have shared. So when we talk about open courts and access, so I had the occasion to do a matter through video conferencing recently before the Kerala High Court. Now, the issue that I saw much later was that on one hand, you have complete access, and that is the way it is supposed to be before courts. And you also have the ability to view, review, and to reproduce proceedings the way you see it, as in through reporting. Now, these reports do not really form the basis to decide the truth or veracity of the proceedings per se. But today, there is a possibility of a recording and a possibility of people also violating, because when you come to a court, you're not allowed to record what is going on inside the court. You only record it mentally. Right? Today, however, with technology facilitating many things, there is nothing which can stop somebody from recording what is happening in the court within within their private premises, over which the court really does not have a right. A lot of other issues have also been raised in terms of the maintaining the propriety of proceedings, ensuring that everybody is formally turned out. They don't really act like they are, or they actually may be in their full side, but that doesn't really allow them to behave in the same manner. So this whole aspect of, starting from the conduct of counsel, the conduct of proceedings, the integrity of those proceedings, and the mode and manner in which the witnesses or the litigants can be addressed are all issues that ties in with this whole aspect of access. So when we are talking about access per se, on the first hand or on one hand, I would say that doing your proceedings through a virtual court actually expands this opportunity of access. But there is also a reality check here. And that reality check is that not enough connectivity is really there in India. We may be talking predominantly of an urban story when we speak about connectivity and how much or how many millions or billions are connected in India. So the numbers can be very deceptive. We have to take into account the possibility that one person may be connected in more than one manner, and therefore the counts don't necessarily reflect the numbers. So one study points to nearly 73 or 75% of India not really having internet access. access. I was doing this study with respect to domestic violence, which I'll be touching upon also going forward, for an NGO. And I was shocked to see that nearly 45% of women do not even have a smartphone. So they're not connected to the internet, and they're also not even connected, because for us, we also take mobile pervasiveness as a ground for assuming internet connectivity across India. And these were all reality checks which showed that if virtual courts are to become a reality and also ensure that justice really reaches out to every individual, we will have to take into account that 45% of women or a 75% of the Indian public in general and meet that challenge through physical and feasible means. One possibility, I'm kind of jumping the gun here because it forms part of my last or penultimate slide, but one suggestion which I'm throwing out here itself for everybody to mull over is the possibility of one, the courts creating certain infrastructure for the courts to to participate in virtual courts, and also for lawyers and litigants who may not have technology to support them in being part of these proceedings to have access to. And I'm saying this beyond COVID. Even during COVID, this is one of the issues that has already been brought up before the Supreme Court when it has said that from next week, it will be starting these processes from their chair. They will be sitting in the actual courts. However, the lawyers can sit in their chambers or at home and conduct the proceedings. So, in this instance, also, this aspect of providing a facility for people who may not have the technology to come to the premises, ensure social distancing, and still avail of this facility has been given as an option. When we look at expanding this across India, we would have to take practical feasibility studies in providing it with sufficient granularity, sufficiently for it to percolate down to grassroots level to ensure that not only is there accessibility, but it is within reach and easily available at no cost or low cost. This is just one case I've put out in terms of public trials and why it is so important with respect to ensuring public confidence in the administration of justice. But let's also take a reality check before we move forward in terms of access and virtual courts. What do we really see in physical courts today? I'm now nearly, if I include my internship phase, I'm nearly about 33 years in this field and completed 29 and getting into my 30th year of practice also. From the days, early days when we would be allowed, we would just access courts without having to worry about security or identity, etc. We could just walk in, right? Um, and we could walk into any court, view proceedings, learn from it, and also participate. Today, and I come originally from the Madras High Court, and from 2000 I've been in the Bombay High Court, and from about nearly from 2015 regularly before this. So when I look at these three experiences, and this is the way I have seen the world go. When I go back to the Madras High Court today, what I see is a fortress. One of the most beautiful premises is now very sadly diluted in its appearance with a metal fortress which doesn't allow you easy access to all spaces. You have to go through a very stringent process for entry. So when we talk about public access and confidence, already the physical access to courts stands much diluted. So when we are talking possibly of a restricted entry to courts to ensure that the bandwidth of courts, which is fairly limited today, is still sufficient to ensure access, are we really depriving public of access? I would say not really. Because when we talk about a physical court saying, oh, you should first say, which is the case you're coming here for. An advocate on record has to give you a pass, meaning like a affirmation that you are there for a particular case. And using that advocate on record's affirmative voucher, you get your pass made. And I'm here primarily talking about the Supreme Court. So you are having very limited access. If you have to access for the sake of, and because when we talk about access, a lot of issues come up in terms of also the press having access so that they can report proceedings. The press do have easy access and complete access. Anybody who wishes to just visit the court can also visit. There is no impediment or restriction on that, but there is a very stringent procedure to that. Applying the same rationale to virtual, are a party in the proceeding that is being heard, you will be allowed entry half an hour before that and up to maybe a 15 minutes after, so that it allows you to be there, start, and then complete and step out and make space for someone else. It's perfectly a still valid means of access. And where access is not being denied to journalists or to persons reporting on these proceedings, and where they are being given this opportunity of virtual access, which may be much more um, easy, much more viable as an option, then I would say that access necessarily does not really suffer from the use of virtual options. Now, when we talk about jurisdiction, and this is where I thought I'll very briefly touch upon domestic violence and why we need to think of virtual courts today. In fact, from the discussions that I've heard, I'm very glad to see we're not really looking at this as a topic for future use. It is already there, it has already been there, and I will be touching upon that. And primarily in the evolutionary process that Indian courts have seen, spearheaded, I think Justice had already mentioned about it, spearheaded by the Supreme Court, of setting up e-courts. So the advantage we have today is we have learnings, we have a lot of examples or illustrations from e-courts to carry forward to the virtual realms in a much wider space. But why do you need it right away, right now, right there? Is because of the manner in which crimes against women and children are also evolving. And I'm not talking about crimes only within the domain of criminal courts, but also family courts. You have a situation today, we are talking about divorce, we are talking about separation, we are talking about various other proceedings that are pending before the courts. But imagine this situation. You have cases already filed of domestic violence. You have cases filed of for divorce or separation on grounds of domestic violence. And today with COVID, you have a situation of the victims being in lockdown with their tormentors. What is the remedy that we are giving out? And this was, in fact, the background to which I did my research and what I was mentioning about earlier about women not having connectivity, even with smartphones, to even submit a complaint if they are being subjected to physical abuse. So, some remedies have already been evolved, but we still stand a long way ahead in terms of finding future remedies. So, one further argument I was thinking of as a supporting one for virtual courts was the ease of access we can give to victims if it is made virtual, and particularly for filing of complaints, right, and for taking up the proceedings. Because for subsequent processes, either through legal aid or through their appearances in person, they may be given opportunities, but the very first stage of filing itself is made much easier when we make it virtual. Now, this is just a provision which I had already talked about, which is I'm not really talking about divorces or but primarily preventive protective measures that are needed in even the current day scenario of a lockdown. Now, there are certain aspects, and these are the slides I would like to really rush through because they've already been dealt with in detail. I may be relying on some of these directions in some argue the issues and concerns with respect to virtual courts. But very, very quickly, you already know that the video conferencing facilities by courts is already a reality, and this has been happening, and progressively the number of cases that are being dealt with using this technology is increasing. But the clarification or qualifier I would put here is when we are talking about virtual courts, we are not just talking about the use of video conferencing as a means of communication. That is just one aspect of a virtual court. So I suppose that I should pause here now and just explain what is it that we mean by a virtual court. And what do I mean by e-courts as distinguished from a virtual court? So the e-court concept was that everything that forms part of the proceedings in a matter, from filing to replies to written submissions, affidavits, and whatnot, will all be done using only electronic technology. Apart from saving paper, a lot of arguments have been put forth in various conferences held supporting e-courts to the extent of even ensuring transparency and certainty. The methodologies that have been used for retention of these submissions, for retention of documents filed in e-form and not having to seek or worry about the retention of original documents before the courts unless and until that stage is needed are just some of the things that have been put forth in support of e-courts. The primary distinction when we talk about e-courts and virtual courts is that whilst everything else is in e-form, the actual submission of proceedings, arguments, conduct of trials, examination of witnesses, etc., were happening and would continue if it is just e-courts in physical form. So, whilst all preliminary aspects are done using technology, the actual proceedings take place in physical form. Now, when we move forward to a virtual court, we are talking about all of these aspects which comprise the procedures for e-courts, which is from filing to the finality of the case, everything happens in digital form. So the stage when it comes to physical hearings are also or will also happen using video conferencing technologies. The issues with respect to security, etc., I will also be dealing with going forward. So the scaling up of e-courts to virtual courts, as you can see, is a very, very small step. And if I were to take the classic of, one step for one step for Neil Armstrong, but a huge step for mankind, etc. I would say it is literally that way because we are really looking at taking a very small step, but a very relevant step. And that step will probably bring up a lot more issues and concerns than all the steps that we have already taken to digitize or to move to the digital medium with respect to preliminary processes. So the Supreme Court, and one aspect here which I want to highlight here is the last part. I don't know if you're able to view it, but of consent of parties. So you need to have your facilities in place, you need to have consent, and you must have a methodology that will secure the open court process as well as the integrity of the proceedings. So when we take this directions further, what do we feel? What are we faced with? I thought this would just give pause for a little lighter moment, but I also thought this becomes relevant because we have been talking about e-courts. We've been speaking about the kind of expense that is involved in setting up e-courts and its feasibility, and some experimental processes have already happened before the High Court. leading, of course, with Delhi. But COVID changed a lot of things. According to me, the biggest change that COVID brought about was it took away the resistance that all of us have as a natural reaction to change. It doesn't matter whether the change is small or big. Every single instance of change, and one of the most recent examples I can use is the Commercial Courts Act, so which met with great resistance when it was introduced. So the whole aspect of change, as or I would put it as as certain is change, so is resistance to it, right? So what COVID did was it reduced the period of resistance because of expediency, because we needed these new technologies. It allowed for new methodologies to grow much faster, and possibly even a 10 or 15-year window, or maybe even longer, has been reduced to a few days or months. And the few days and months is an evolutionary process because you can't change everything overnight. And we will have to look at how we can use technology for moving forward. And now, in taking these arguments further, I'll be relying not just on judgments that are COVID time, as I call it, but also pre-COVID time. And this will show you how it's not something new. Use of video conferencing for various purposes is not just new or something we need to adapt only now. It is only the scale of adaptation, it is only the scale of usage that we are really looking at increasing. So, in this judgment, when the Supreme Court had to deal with the consent of parties, the majority judgment upheld the need for consent. And Justice Chandrachud's dissenting opinion, of course, talks to the contrary with respect to this, because it's the whole issue is with respect to when do you need consent or otherwise. And primarily, of course, this was a case that came out of Family Courts Act. Now, the issue that arises in this case is that if we only say consent becomes the first level, a threshold level, or an entry level necessity, then will that defeat the entire process itself? To just take one example, if let's just look at the Domestic Violence Act cases of maintenance, for instance. Naturally, the victim will want the proceedings to move further faster, and they will want to take whatever is the immediate available option. The perpetrator will not have any tearing hurry for the case to be taken up. So, for want of consent of one of the parties, should proceedings be delayed? So this whole issue about consent, therefore, takes on a lot of nuancing and is not necessarily a binary situation. Then this aspect with respect to demeanor of witnesses, of for a judge to understand and to feel and to be able to read the witness is another issue that has already been raised also. Right? And this is where, in a way, I thought of and decided to introduce the e-commerce aspect of it. Many times people believe that a lot of these nuancings would be lost in the virtual world. I would say not really so. And I can confidently say that, having been part of these proceedings, except for the fact that we are sitting down and arguing and probably sitting down in our own homes, nothing else changed really. You are addressing a court and you will ensure that the decorum of court is maintained. The court is also fully conversant with the fact that it is conducting judicial proceedings, and therefore it ensures that there is nothing that changes merely because the domain has changed. Similarly, any person who appears before it is not going to really forget that they are still before a court of law. It is not even like an arbitration. And this is where I thought I could take into account the concepts of one arbitration and online arbitrations. in arbitrations, we are sitting in very comfortable surroundings. And that's the whole concept of having to pay more for proceedings which will hopefully move faster, right? So when you're doing that, and when you're having a trial scenario, cross-examination happening, is it that the witness is not in any less a state of alertness? Is it that the person who is cross-examining the witness is in any kind of um, um, a disadvantage? Not really, right? We are not really talking about, and today law has already evolved. Badgering of a witness, badgering of any kind is not permissible, right? So you are really relying on a much higher level of cross-examination and of conducting of proceedings. And I would strongly say that if the same kind of control that a judge ensures in conduct of proceedings physically in the virtual world, these aspects should not really matter. A few cases again, in terms of one, the legality as well as the effectiveness. So, in this judgment, the Supreme Court equated the presence of a witness on par even when the witness is appearing through video conferencing. The conduct of witness, can the witness take things for granted, or will they still be under the same level of alertness and also propriety, right? So this was a case where the defendant objected because the plaintiff had already said that he does visit India regularly. So the Bombay High Court held that it doesn't matter if the plaintiff visits regularly. For expediency, video conferencing facilities can be upheld, especially in this case where the plaintiff then takes the expenses of conduct of video conferencing. But it did caution that the adequate precautions should be taken in terms of the video conferencing, recording of the video conferencing through PC. The other issue that comes up is with respect to whether the witness can cheat, or if the witness is really the person who you who you have been told is the witness. So now I'm really grateful for the conduct of video conferencing facilities. I think it was about I also conducted one piece of a proceeding which pertained to the cross-examination of witnesses from India for a proceeding that was going on in the US. So apart from the discomfort of us having to literally start our proceedings in midnight, everything else could have effectively happened in the same way as recording of evidence before a commissioner and that is something we are already used to in civil proceedings, right? So here was a situation, in fact, which was better than recordings before a commissioner. The number of questions which would be left open-ended, the number of responses that would be recorded by a commissioner with the qualifier that this is subject to a decision by the court with respect to the objections raised by the um, counsel did not happen in these proceedings which I'm talking to with the US. The reason why we were conducting the proceedings late at night was that because the judge was on call to answer these objections as and when the objections were being raised. So when the proceedings were going on before the commissioner was recording these proceedings. When an objection is raised, the question is put to the judge, and the judge would respond immediately in terms of deciding. The arguments are placed and a decision is made, and the proceedings then moves back to the commissioner. So when I take this example with respect to identity of parties or the difficulties in terms of the conduct of proceedings, particularly about whether a witness will cheat, will they look at a document without permission of court, etc., all of these can be easily resolved with the supporting role that counsel and advocates are going to play. There may be a larger burden on them, but nevertheless, it is a burden that only they will be able to meet. But the remedies are definitely there. So here, where there is a situation where the advocates are present, and I'm talking about the COVID times now. So today you do not have the advocates and the client sitting in the same room. So if that were to be so, if the courts were to first verify whether the room has been sanitized sufficiently for a witness to not cheat, and the identity is proven first by the uh, advocates, then there is a possibility for moving forward even with trials. And of course, today, given the directions from the Supreme Court, consent of parties will be needed. And where there is a need for exemptions, maybe some rules and regulations can be further formulated or put before the court for its consent or approval. So moving forward in terms of, again, a few more cases which talk about, not just use of video conferencing, but also give some ideas on what could the remedies be. Here is a case where it had to be a synchronized process between Dublin, Ireland, and India. Now, what the court said was that that the facilities could be synchronized, and it used the assistance of the Indian embassy in Dublin to authenticate the proceedings. And then it laid down the guidelines for how the video conferencing could be done without the witness having to travel to India. This is about the identity of the witness and the accuracy of the equipment used for the purpose to be ensured. But when we look at all these cases, one, there is a caution that is put up, and two, some guidelines have been provided. So you have both to help you. And when you look at these years, you realize it's way before COVID. So all of these are just things which lead us now to this COVID phase, which we can put all these cases to good use. I want to just rush forward to the move because I realize that I may be running out of time now. When we talk about recording of evidence, now we are used to, and I still remember the old days, and I would tell people that trial proceedings are not as exciting or fun as you see in movies, because first the lawyer has to ask a question, and then the witness has to answer, and then the judge captures it, and then it is typed out. And we are talking about from typewriter days today to the computer. So when we moved from typewriting to computers, what has really changed? When we can now go back and make corrections with respect to what is input in a computer. But the methodology of verification before a witness authenticates that statement remains the same. So you would have a computer generated printout which is furnished to the witness. The witness is expected to go through that and then sign. And the Supreme Court in this judgment held that even the recording using mechanical processes is the same as. Again, moving forward, this is of a Karnataka High Court, again, which emphasizes what I've already mentioned that the Supreme Court said. I thought this was an interesting case I could rely on, especially when it is from your parent High Court. In a case where parties wanted to register their marriage and they were not physically present, the Jharkhand High Court allowed for the affirmation of the marriage through power of attorney, and the physical presence of the parties was secured through video conferencing. This is a case which shows that technology indeed is going to evolve tried and tested methodologies. The issues that arise, and now I'm going to move into the cyber realm. Are we just using old techniques for new technology? Meaning, when I'm talking about the whole process of a virtual court, forget about the whole stage of filing of pleadings, affidavits, documents which will be digitized and uploaded, replies and rejoinders, everything. Even order copies, it is very easy for you to upload with your digital secure signature or your DSCs, which you're already familiar with, right? So you have a secure digital signature which you can use to authenticate all of these. The issue really arises about when you're doing your video conferencing, and especially now when we are talking about COVID times, is it really going to be so problematic? Because, for instance, Malvika talked about how her statement was authenticated through the use of a notary public. Today, you don't have a notary public sitting in everybody's home. So who is going to authenticate the evidence if you start conducting trials during COVID times? So two things I wanted to emphasize here, which can be a solution during COVID times as well as in the future. You have two different kinds of digital signatures that is captured in the Information Technology Act 2000. Going forward, if I use IT Act, I mean the Information. The first is an electronic signature and the second is a digital signature. So the second aspect of digital signature is what is called as a secure electronic signature, right? The first aspect, and therefore digital signatures form part of the broader genus of electronic signatures. When you talk about other kinds of electronic signatures, what do you have? Today, you have a second schedule to the IT Act, and what the law says is that whatever is captured in the second schedule as a methodology and is reliable can be used to authenticate uh, using e-forms. Now, the beauty about the evolution that has happened on till date, and I still remember the old days when it would be a very, very long drawn process for getting a digital signature, and today it is actually much more so. Because of abuse of digital signatures, today you need to submit a form, you have to give your KYC with respect to who you are and what you are, etc. And after all the preliminary verification process is completed, you also have to download an app and do a video recording confirming your identity. I'm setting out these things very explicitly and I will show why going forward. So when we talk about these kind of authentications, these authenticate the person to whom a digital signature is given. The second stage of it is the use of the digital signature by that person to authenticate a record. So when that person uses that signature to authenticate the record, it is deemed to be the signature of the person to whom it is issued. If there is an objection to that, and if I were to say, but I am NS Napannai, I did not come and present before the Jharkhand Judicial Academy, somebody else pretending to be me came and gave this session, then the onus of showing that I did not do it lies with me. Otherwise, there is a deeming provision in law which says that it can be accepted if it is using a digital signature. You cannot go, and all of us technically have a digital signature certificate because if we are filing our returns. But because of that, there is also a problem. The digital signature certificate may not be with us today. It will be with our CA, and there are difficulties in terms of transference of that. So today, if we are talking about recording of evidence and for witnesses to authenticate the process, then how can it be done? You do have processes within 5 minutes of generating e-sign. Well, 5 minutes is an exaggeration probably, but all that it needs is a KYC process, and you will get an e-sign which will work only for that period of half an hour. And thereby you're ensuring that the same person who has given evidence is also using the signature. Right? So you all the procedures for the issuance of an e-sign can be done online. And it is a one-time. And with all of these, the authenticity, the reliability and integrity of the signature are being ensured. And there are very specific entities in India who have been allowed to issue these e-signs, and therefore the onus, if there is any objection, would lie on those entities to prove that it was indeed an sign given to so and so person. Thereafter, the onus of proving that it was not the person to whom the e-sign was given who applied it lies on that person. And here again comes the role of advocates who will then have to authenticate that indeed this signature has been applied by this witness or by their parties who may have to file certain things with signatures before the court. So these are all procedures which are already available with us and can be used in proceedings today. The last part I had already touched upon, the goldfish bowl syndrome. There again, the only issue that I think that can be addressed by the courts is to ensure that whatever people are recording, one is that you put down a rule and the sanction for violation of it. If in spite of that somebody records and puts up, then they can be called up for that. And this was already touched upon. And with my qualifier that I'm not fully familiar with family courts, I would still say you have a lot of leeway with respect to the Evidence Act and flexibility there, including even for submitting of, let's say, a 65B certificate for electronic evidence. So with that flexibility that you have, I would say the impediments for conducting trials or proceedings involving recording of evidence is much less for a family court than it is for other proceedings. Going forward, and this is just another case again, where you get a lot of guidance in terms of the method of recording of evidence and how you use that up to the stage of 313. And for those who may not be familiar with criminal proceedings, 313 is the process of recording the statement of the accused. Again, moving forward, this is a very, very quick case from the Madras High Court which says, can it be used for matrimonial cases? Of course it can be. My concern is with all these judgments preceding COVID times, but with the COVID directions talking about consent, that is one issue which I feel there has to be some kind of parity or a clarificatory order that will have to come, and that will come from the Supreme Court only when this issue is raised before them, right? The last part of my presentation before I move on to the Q&A aspects are the security challenges. Now, whenever we talk about technology or use of technology in court processes, we are always going to be met with this challenge. And this was the challenge which was argued at length, and I was very lucky to be part of that proceeding also before the National Judicial Academy, in terms of discussing what are the issues or concerns that should be addressed before courts move to e-courts. So I would just say that the learnings and the suggestions and the implementation processes we already have can be taken forward to improve further processes. And finally, before we move forward to a closure on this, are we only talking about hypothetical situations or are they already there? And it may seem strange to use any kind of an example from China because we always believe that, a democratic process may not necessarily be able to adapt everything from an autocratic process. But here are circumstances, here are situations, here are methodologies that China has evolved for its commercial court processes, and these can very well be adapted across the board for all processes for India or for that matter any part. And these effectively are what I have also called out here. In this aspect, use of electronic or secure electronic signature, use of hash values to ensure the authenticity of pleadings and non-modifications thereto, time stamping of all these submissions that are being put, are all things which can be done with procedures, what we call as practice directions, which courts have already given, and that was something, in fact, I worked on. I was part of the team which drafted the Commercial Courts Act, and I can tell you that the entire process with respect to practice directions for e-filings, which I was primarily driving, drafting of it, are all aspects which can be used by any court to do. This gives you a lot of directions in terms of how courts can function without the presence gives to us. Right? The second point which I put here of use of blockchain as a solution is something that I have been espousing extensively because blockchain can root out a lot of things, including corruption, absence of transparency in processes, or rather, it can ensure transparency. It can ensure that the integrity of a process. So, with all the advantages that blockchain can bring, this is a technology which will have to be developed, however, for its adaptation. So, it is in a way a little bit of a futuristic issue. And when you look at the other aspects that we get from China, very interesting. The one thing which I am not very comfortable with is the way they verify your identity. Since Alibaba is one of the largest and most involved probably, or for whatever reason, Alibaba's Alipay is used as an option for you to verify your identity, or you may go in person and verify your identity. So, given the fact that most people compromise their privacy for the sake of convenience, chances that Alibaba is now therefore collecting the personal data of many a litigant is not so far-fetched as a possibility. So I do not approve or support this aspect of physical verification, but this is the reason why I elaborated upon the KYC processes that you have to use today for confirming your identity or getting a secure digital signature. If we adapt those kind of methodologies and SOPs, we have before us today a very easy to follow process for verifying identity of a person. With respect to the filing of pleadings and evidence, as far as pleadings are concerned, we already have the law. We also already have the law, including in the Family Courts Act, for affidavits to be filed with affirmation. I've already explained how that affirmation can happen sitting at home. So all that remains is for cross-examination to be conducted using video conferencing, and that by itself, considering the kind of success that India has seen in continuing with its legal proceedings using video conferencing, should not be so difficult. Moving forward, online arbitration we have already addressed. So just to move very quickly forward, again, this issue of how much time it saves for people was highlighted. In fact, when I was invited to give this session on a Sunday afternoon, I was thinking how convenient is it that I don't have to spend my entire weekend traveling to Jharkhand. By the way, I love to come to Jharkhand, and particularly though I've only seen Ranchi so far. But yes, whilst I love coming there, it still is very time saving, and it also saves a lot of cost and effort, right? So, given this, and I thought this was a perfect case to rely on at this juncture to show how it is not just the witness, it is everybody from the lawyers to the litigants, everybody gets to benefit through a much more streamlined and efficient process. The setting up of the process, as with anything new, will have teething problems, will have a lot of pain points. But once we get past that, then we will be able to move ahead much more smoothly. And within a very short time of probably a few months, we would possibly see, we will wonder what were we doing not implementing all this earlier? Why would we have to wait for COVID for all this, right? So I finish off on a little bit of a philosophical note, and I draw from Justice Ravindra Bhatt's session here. If you Google this, you will find the session, and you will find one thing, and this is why I wanted to finish here with this, the qualifier, that Justice Bhatt believes that when it comes to recording of evidence, etc., where you need to evaluate the demeanor of witnesses, etc., it may still be more expedient for you to do this physically. My argument being contrary, I thought it is only right that I conclude by putting the contra argument also before you to say that there are two ways we can look at it. One is that we ensure immediate justice by using technologies, and we always evaluate where there is a trust deficit. And I believe that as trained judges, every single one of you is capable of reading into body language. If you believe that somebody is not really conducting themselves commensurate with the threshold that the court puts for integrity, it is open to the court to pause the proceedings and to insist on the physical presence of the witness. But to just eschew technology, to run away from it, will not help us. So I would in fact take Justice Bhatt's saying and reverse it. And I'm using the Advaitic monism construct here by using the rope and snake example to say that what you see may be real in terms of a rope, or Maya in terms of a snake. So your fears may just be Maya, which is the snake, and the rope may be the reality. But it may very well be the reverse also. But it all depends on the way you look at things, and then the things will look different to you. So try it out. It is not going to harm anybody. And today with COVID times, and probably maybe even a month or so ahead of us, It is high time we adapt to technology to see how best it works for us. If it doesn't, nothing stops us from reversing the clock. If it does, then it expedites us moving forward. So with that, thank you all, and I am
Marie, may I request your lordship to give the concluding remark?
Thank you. In fact, the last summation actually which you did of the rope and the snake thing, that leaves the lasting impression on my mind and the rest of us also. We really have to look at things in a way so as to affect the age. And this whole concept of perception of things has to change. And in the last about 1 hour, the way you present the contemporary scenario and how we are gearing up to, at least so far as the judiciary, to take up the challenges, transition from physical courts to virtual courts, the midway in between, not necessarily virtual courts in non-nature of cases. This has been a very illuminating experience for me, as well as I am sure for the family court judges. This is a very in-depth analysis. I also had the occasion to go through many papers on this transition being undertaken and how in India we are still a bit lagging behind in those terms. Some jurisdictions have gone ahead. And to share with you others also, especially this challenge of conducting trial and examination of witnesses through video conferencing, which is being thought about in these COVID times to come. We actually are working on a video conferencing rule, where this has, of course, been prepared by the Supreme Court, the committee, and given to us the model rules also with our inputs. And this, of course, is after study of many comparative also. This whole challenge actually is to be met with a great deal of control over the trial court proceedings done at a remote point, ensuring that that remote point is also a proceeding or a court controlled proceedings, not a proceedings in a remote point where the court doesn't have any control. And therefore, the concept of coordinator and the person at the remote point would be a coordinator who would have control of the proceedings there, so that the witness or the lawyer or the participant doesn't vitiate the whole process, the integrity of the process. These things are being seriously discussed and are most likely to come in the coming few months. And I know for the family court judges, of course, this would be a very new concept coming to them, those who may not be keeping abreast with the changing times. But it has been a very absorbing session addressed by you, Ms. Napinai, as it always happens whenever you have come to Ranchi also. And that cyber crime conference also, we had the benefit of listening to you. And I thank you for joining. At least you have been avoided the trouble of coming physically to Ranchi in this COVID time. And this would, of course, be proving to be useful in future also, even though the travel restrictions might be lifted in due course of time. Thank you.
But Justice, I do hope to still come to Ranchi though.
You are always welcome, and Mr. Rasgotia, you are also always welcome here. And really, I'm very thankful on behalf of the High Court and Judicial Academy to have shared your views, and we are hugely benefited by that. Thank you so much.
Thank you all for having us.
Thank you very much. With this, we are at the, with the permission of the chair, we close this session, this brief session. And on behalf of the Judicial Academy, I thank all of you, my lord, and the resource persons and the participants. Thank you. Thank you very much.
Thank you.